All right, welcome to the Litigator's Lounge, where we delve into the intricate world of commercial litigation with Offit Kurman's Commercial Litigators. I am Anders Sleight, the practice group leader for Offit Kurman's Commercial Litigation South Practice Group. Joining me today is my wonderful and experienced trial lawyer colleague, Caroline Callahan. Caroline, welcome. How are you doing today?
I'm doing well. How are you today, Anders?
I'm well, thank you. Caroline, I understand you're an experienced trial lawyer, so what are some key things that clients should be prepared for when they're getting ready for a trial?
Sure. One of the best thing that a client can do to help prepare for a trial is be actively participating. A lot of clients will hand over a lawsuit to their attorney and expect the attorney to run with it. And of course, that is exactly what we're doing. We are running with it, but we need a lot of help from you. The case is coming from you, the information is coming from you, the documents are coming from you. So the number one thing I tell all my clients, and that I try to reinforce as much as possible, is make sure you've turned over everything to your client, to your attorney. And I mean everything. Mostly important is the documents. The number of times that a client has presented me with a very important email, very important document, 2 weeks before trial, I can't even tell you how many times that happens. And unfortunately, in every single jurisdiction you're going to be in, there are deadlines that you have to give that information over to opposing counsel. This is not like it looks like on TV where you present a key document at trial and everyone's big surprise and there's a lot of oohs and ahs. That is not allowed. That is kind of the biggest misconception out there. It's not allowed. You have to turn over everything way beforehand. Depending on the jurisdiction, that deadline can be 30 days beforehand, 60 days beforehand. Check with your attorney, but it has to be produced ahead of time. So if you have not turned it over to your attorney, then it's like it doesn't exist. So that's the biggest thing, is make sure you've turned over everything. And by everything, I mean every email. That's usually where clients fall down, is they have not produced the emails that they need to produce.
What are the sorts of records and documents that you're referring to that clients should be prepared to turn over?
Sure. The simple ones people think about are the contracts. That's almost always turned over. But again, the meat is usually in how the contracts were done after they've written and how they were performed. So a lot of that comes into emails that were exchanged between the parties on what the contract was supposed to be about, or how was the relationship between the parties. Where did the breakdown start happening between the relationship? Most of that nowadays is in emails or chats or text messages. So all of that sort of technology information needs to be turned over to your attorney, because they need to go through it and make sure that, hopefully there's something good in there for you. And on the other side, there might be something bad, and that will influence, obviously, the trial. It will influence any kind of negotiations up till trial.
If I'm a company, I'm involved in a trial getting ready to come forward, who should I expect to be involved in that trial? Just one particular person, or how does that work?
It obviously really depends on the case, but usually there's you want one point person at the company that knows everything, and then you'll also have sort of those sub people that were actively involved in the dispute, in the issues that are at hand. You're going to need kind of all of them. So that is one thing you need to think about. If you have employees leaving, make sure you've got their contact information, because, especially with contract claims, they can be 5-10 years old. Try to keep track of people if they leave your company.
You never know when you may need to track a witness down, or particularly
Exactly.
if it's an employee who's left, a key employee maybe who left at some point in the past, right?
Absolutely, because you're going to maybe need to get in contact with them. Hopefully they'll agree to appear in support of you, but if for some reason they're not interested in doing that, you might have to issue a subpoena, which means you need their address. You need to know where they're living. Not that you need to continually stalk them, but do your best to keep track.
What should a client expect when you're actually at trial?
So if you get to trial, then what you should expect is that your attorney will have worked with you a lot beforehand. You will have created a strategy, and you should also expect for that strategy to go out the window at some point. Trials are very, a time to be on your toes. You never know what's going to happen. You don't know what kind of jury you're going to get if it's a jury trial. You don't know your judge sometimes until the day of, so you won't necessarily know what their tendencies are. Judges can make mistakes and do rulings that are incorrect, but you can't fix that mistake during a trial. That's something that has to be dealt with on appeal. So you might just have to roll with that. The judge is like an ump. Sometimes they make bad calls and you just have to go with it. So you never know what's going to happen. There could be unexpected testimony. Opposing counsel could do something completely crazy. So even though you've worked out a strategy with your attorney, it might go out the window. And they're obviously going to have to roll with it, and you're going to have to roll with it with them.
Thank you, Caroline. That's a wonderful tidbit, so we'll appreciate those lessons. Just as a reminder, Offit Kurman Commercial Litigation Department is a coast-to-coast operation. We have litigators spanning the coasts and focusing on industries such as real estate, financial services, employment, government contracts, construction, as well as routine business disputes and matters. Caroline is an experienced trial lawyer herself. Why don't you just share briefly about your background, Caroline?
Sure. I am barred and have done trials in Maryland, DC, and Virginia, both in sort of the DC area and broader out. I think the vast majority have been successful, and a lot of that is I've had good clients who have good record keeping, and also just a cooperative relationship where you can get a good case together and present it.
Well, thank you. Thank you so much for joining me, Caroline. I really appreciate your time and sharing your wisdom. We'll look forward to hearing further from you and sharing more with you all in the months to come. Thank you so much.
Thank you.